We should be good here.
Uh, y'all ready? So this is the subcommittee of the Ethics Committee on considering the AI uh, ethics opinion, proposed ethics opinion. The members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. All of y'all have been on this multiple meetings, so I will assume that we have no conflicts that have arisen since Christmas. And with that, do you want to tell us about, Brian, do you want to tell us about, look at Tara, she did make it.
Look at that.
Uh, man, with her,
Hello, Tara.
hopefully with her baby in tow. So you want to tell us about the uh, additions and changes you made subsequent to our last subcommittee meeting for
Yeah,
this opinion that we will probably want to present next week.
yeah. So I'll hello, Tara. Good to see you.
So sorry for the delay. I was in court running to a conference room.
Oh
Oh,
man, you're back at it. Look at you. Wonder Woman. So here we go. Let's talk about this opinion. I'm going to share my screen so we're looking at the same thing as always. The opinion was circulated, and there's a lot of stuff that we talked about at this at our last meeting, and the additions that I made were based upon our conversation and really just trying to kind of I would say enhance the opinions, both like educational capability on the broader topic, as well as the specifics for, just what is someone supposed to consider. We were talking about like using a third party's resource or AI program or what have you. So we'll get into this. The stuff that you see here in the background, I tried to just kind of again kind of beef up what we're talking about, maybe give some terms and offer some very brief examples. This is one of those things that you could start going down the rabbit hole of all sorts of different aspects of AI, and instead of giving a kind of a almost like a treatise on on AI, I footnoted a lot of different resources that might be helpful to folks from whether it's from Lexis. There's some good stuff on Lexis about AI in the legal profession. You see some references from IBM just on what exactly is AI in that particular resource. If you look at it, it's got a number of different things that you can click on of just to understand more about what is AI today, how does it like the different terminology, the different just a whole bunch of different pathways. So again, really just trying to give folks a sense, like we talked about in the last meeting, of you know we want to educate folks. There are folks that are reading this that don't understand exactly what AI is, or they hear about it, but they don't fully grasp it, and they need maybe some direction on where they can learn more. This is not going to be the end all be all educational document on AI, nor really should it be, because it'll be outdated very quickly. But at least we can give folks some resources that they can look at and educate themselves if they want to go further into it. I'm going to go through all these different changes, and then we can kind of go back and maybe start at the beginning with whatever else we want to discuss. The first inquiry, I included a general thing. We had this first comment about one of the sentences that kind of conflicted with a later statement in the paragraph, or excuse me, in the opinion, about whether or not a lawyer has a responsibility to inform the client about their use of AI. And, the opinion, the later opinion that addresses that question stays the same. I think we all kind of agreed that the opinion as drafted was correct. That a lawyer doesn't have an automatic duty. There may come or may experience some sort of responsibility, if not requirement, to talk with a client, particularly when it comes to billing issues. If you are relying upon a program to do some sort of analysis that's going to be material to the representation. It's going to be very circumstance specific. I imagine that would be something where we on the ethics staff would get calls from somebody saying, I'm not asking about whether I can use Westlaw. That's not the issue. I'm not asking about whether I can use a case management system that employs some form of AI to manage my things, or maybe even assist with some drafting or drafting assistant program or what have you. But it really needs to be more specific and really kind of material to the representation. So I've just added this word generally, that generally speaking, a lawyer gets to determine whether or not they're going to use AI in their practice, but also noting, I dropped a footnote here to just say, take a look at this later opinion, though, because there may be a circumstance where you may need to talk with your client or consult with your client about your use of AI. And then included a sentence here in the middle of this last paragraph that really just kind of tries to, again, emphasize that, yes, lawyers, if you're going to use AI, you need to do so competently. And to achieve that competence, you need to educate yourself, and some of those educational efforts really may include reviewing current and relevant resources on not just AI broadly, but also the specific program that you use. And we get into that in more detail, a little bit later, of course, in the background, but really just trying to emphasize that point that education and constant education is needed because this technology is rapidly evolving. My understanding of AI from all the flurry in 2023, I feel like needs to be updated here in 2024 because it's already changing. So that was the addition to inquiry number 1. Inquiry 2 and 3 is where we start talking about third-party programs, whether it's a lawyer sending or utilizing a third-party program or a law firm that is creating its own AI, kind of in-house AI program, which sometimes are based upon third-party programs. And so in this particular one, inquiry number 2, this is where some of the conversation was focused on adding more information about confidentiality and really some of the considerations a lawyer needs to take into account when evaluating their use of a particular program, really kind of like what to look for, I think is the best way to describe it. So I kind of expanded a bit on why this is important. What are the professional responsibility parameters here as far as a lawyer needing to make, take these reasonable efforts to make sure that information, confidential client information, does not get inadvertently disclosed or is somehow unauthorized, accessed in an unauthorized manner. But again, teasing out just what does that mean for reasonable efforts? What are the factors that should be considered? Citations to like the comments in Rule 1.6, but really just trying to bring it home to say that a lawyer needs to, particularly this quote from 2008 FEO5, a lawyer has to take steps to minimize the risk of confidential client information being inadvertently disclosed, and just trying to equip lawyers with some of these thought processes. And then getting in, I pulled from 2011 FEO6, which was the opinion dealing with a lawyer's use of software as a service, and very broadly, and how that opinion talked about different considerations for a lawyer to make when evaluating a company. Maybe you look at their reputation, their experience, their stability. Are we talking about Microsoft, or are we talking about your friend down the block that said, I have a bunch of servers in my basement and I'm trying to get into the cloud game, that sort of thing. But then there's also considerations for the terms of service. When you're using a program, how is the information used? How is it stored? What safeguards is the third-party program putting into place to make sure that the information is still secure? And then even kind of like the afterthought, which was articulated by the Florida bar. I remember we talked about that Florida opinion, the proposed opinion, which is not yet officially adopted, but I think it's supposed to be considered sometime this month or next month by the Florida bar for adoption. But they talk about ownership information. This question of if you put stuff into their system, do they now own it? And they being the third party company, can use it to train their AI program on the information for increased capability, services, all that kind of stuff. And just all these different considerations that a lawyer needs to, or maybe it'd be wise for a lawyer to look into when using a third party. So again, trying to provide more specific issues to think of, as opposed to just saying you need to make reasonable efforts to make sure that stuff isn't inadvertently disclosed, but to give some thought processes, like start the wheels turning of what exactly should a lawyer look at when using a third party program. We've said it before in that 2011 opinion, and we're saying it again here because it is still applicable. It's, really the difference is that AI is just, it's so much, so much more significant than what we had before when we were looking at, cloud storage. We're dealing with a different beast here. So again, try to kind of tease that out, make it hopefully helpful to lawyers in trying to get their thought process going. Referencing again, opinion 3 kind of talks about some of the things in opinion 2, and just want to make that specific connection between the two opinions to see, whether you're talking about having a third party or using a third party's program, or whether you're talking about having something built in-house, whether it is or is not based upon some public version of this the company that's implementing or designing your AI process, that you still need to look at their terms of agreement too. The terms of service for how they're handling your information and how their program interacts with your information, particularly whether it gets sent back to the kind of to the hub, to the hive mind for additional training. Those were the biggest changes. You see opinions 4, 5, and 6 basically stayed the same. Those are the ones dealing with billing and whether or not a lawyer needs to inform their client about the use of AI. But it's just one of those things, I guess, based on after I rewatched our conversation, looked over my notes, I think the biggest changes were in opinions 1, 2, and 3, and just trying to make this more accessible and helpful to lawyers as they start down this pathway of considering, or maybe continue the pathway of using artificial intelligence in their practice. So with that said, that's my long-winded summary of the changes. And Warren, I don't know if you want to start us off with any questions or just want to open it up for discussion.
I have no changes, no notes. I think it's quite great, but let's open that up, see if anybody wanted to has any other comments about it.
Warren, it's Craig. Good morning, everybody. My overarching comment is excellent work in terms of dealing with the confidentiality aspects of AI, because I do think that's one of the most compelling issues that lawyers confront in connection with use of this new technology. So I think this is more robust and helpful. I did have one question for you, Brian. Is there one resource that you would say is the best primer for lawyers when it comes to use of AI in connection with the practice of law? I know you have many of the good sources kind of footnoted at this footnote number 2, but I'm just wondering, is there one that we should maybe focus on and bring up into the body of the document and say this is a good starting point for purposes of getting acquainted with how AI intersects with law practice?
Right. So Craig, you're hitting on something that I was, I feel like I just keep on saying, I was struggling with these different aspects. This opinion is a struggle because you're right. The ones, both the IBM resource and the ones in footnote number 2 and the Lexis article, which is not really an article, the AI terms for legal professionals. That link is actually to a page that has some different pathways of, how this stuff interacts with the legal profession. The IBM one, I think, is a very good one just to understand what we're talking about artificial intelligence very broadly, but it's not as specific to lawyers and the practice of law. So you kind of have to make those connections yourself. And the reality is, in my experience, my personal feeling is the best resource is a person who knows a lot about this, because every single resource, it feels like, I was bouncing between different resources. seeing that, okay, this one from Lexis is really good, but it doesn't really pull out all of the different ones. There's a distinction in there about generative versus extractive AI and all that stuff. But then there's other machine learning processes and large language models and all this kind of stuff that I see these phrases and they're not addressed in that particular one. So I go to the IBM resource or I go to something else. And that's why I ultimately went with the footnote route, because putting it in the body, you're right, it draws the attention of the reader and it makes it kind of the front and center. This is one that you need to look at. I felt like there was not one that I felt fully confident. If you read just one, read this one. I have kind of a ranking in my head of what's helpful today. But will that change in a couple months? Probably. There might be a new resource out there that's published by any number of particularly legal service providers like Clio or anything like that. Westlaw, Thomson Reuters is starting to launch their Westlaw related AI stuff. I know you all have some experience with them. Lexis is really trying to, I think, take the front spot with a lot of their stuff, but there's some competition going on and there's a lot of resources out there. So that's a long way of saying I don't have a top one. I'll put it this way: I don't have a top one that I feel I would want to put in the body as a draw all attention because to the readers or draw the reader's attention to that particular resource because of everything. I didn't find anything that was just the one-stop shop. And I don't know if maybe I shouldn't be so critical of these resources. Maybe I should put the resources, maybe this is a question to you, Craig, the footnote number 2 resources, would they be better in the body as opposed to a footnote? Because sometimes folks don't pay attention to the footnotes.
No, exactly. I think, there's this tactic that I think some professional writers use in their books to move footnotes outside of the pages into a separate section, which really gives them short shrift. So this is, I think, better. And I understand what you're saying. I fully appreciate the fact that you don't want to just give a lot of credence to one, especially in a world where things change so dramatically. So I understand the process. And I think that unless other members have contrary views, I think the way that you kind of identified these resources and the way you footnoted them as opposed to putting them in the body, that works for me.
Brian or anybody, it surprises me a bit that whether it's the ABA or maybe our Bar Association's Center for Practice Management, that somebody hasn't taken it upon themselves to aggregate links to resources in the legal context, but you didn't encounter that anywhere?
I haven't seen any, and that's why I see Ellen, you're shaking your head. I was kind of wondering, Ellen, I know you're on top of a lot of the stuff, particularly for academia and other, just of course your students are using it all the time. And so, but I have not seen that yet. I know that there is a task force appointed with the ABA to study AI and so forth. I would like to think that will be one of their products, but I don't know that it's in existence yet. Ellen, have you seen anything?
No, I haven't seen anything aggregated like that. And I think, there's terminology issues, there's all kinds of issues. Most of the stuff, and Brian, your opinion, which is incredible, is reflective of this. It's coming out from vendors, right? It's for-profit companies who are doing my stuff, and they're not bad, right? They're not, but there's not any aggregated list. But I do think we might get something from the ABA. Yeah.
And I think that could be something that that can be updated whenever that becomes available. We have, sometimes you may have come across this in looking at our opinions on the website, but we will sometimes include editor's notes. Even if there's an update, there could be kind of, if we see some sort of great resource, we can put this update in there to say, update, maybe it's, July 2024. Great resource for seeing, for lawyers to look at is this ABA page or whatever, and include a link. So I think that would be something that we should look at. I agree, Lamar. It's kind of surprising, but at the same time, it's like it's all, it's funny thinking it's only been I guess 9 months, 10 months since ChatGPT 4 got released that passed the bar exam. And so there's still a lot to do. But if you all agree with this approach, maybe we can just kind of have a suggestion that this opinion, since it would be the one that people go to on the website, that this opinion basically the editor's notes or whatever, an introductory note can be updated with more recent resources as they get published and as staff encounters them. Just to, again, make it a resource. It's supposed to be an opinion to educate folks, to give them a sense of their professional responsibility when interacting with AI, but those resources are only going to increase. And maybe this
wouldn't that be great where we do have an editor's note? Because if we did it as some footnote that acknowledged that we might discover more resources later on where we don't have to go back and represent the opinion and republish or anything like that, we can just add it as a footnote. That would be good, because I do feel like right now it is all vendors who, not all, but mostly vendors who are writing about it, who are trying to sell some product. So they're not going to alert you to the problems with their product so much necessarily. And well, I guess they'd have to some degree, but more importantly, they're not going to tell you about other vendors who have good or better products or things that they're doing. And it's inevitable that we will start to see people have much more practical experience than one or two sort of experiences we've heard about in the news, where people are actually getting feedback from using these things in the legal setting, where we might have more accurate stuff to put out there. It'd be kind of nice.
I can include whether it's an editor's note. The thing I like about an editor's note is that it's at the top. As our pages are currently constructed. I know we're going to be going through a website overhaul, hopefully in 2024, or at least begin that significant design process. But because the note is at the top, if somebody's clicking on something that perhaps they see this editor's note, that referencing that the footnotes in this opinion contain a number of resources that are helpful for lawyers' education on the subject, and this note section may be updated as resources are developed and published, for future reference or something. Just kind of give folks a heads up that you read this on this particular day, come back in a year, come back in a couple months. This one will be continually updated. I mean, it's one of those things where ideally it starts begging the question of, should there be a separate page for lawyers, the legal practice, and artificial intelligence? That's just kind of it's our own page. It's our aggregate, like Lamar was just saying, of resources that we found helpful. And maybe that's something to consider in the design overhaul of the website. But maybe for now, we just simply include it as an editor's note and let folks know that it will be updated, or it may be updated as things are published and as they become relevant to the subject matter of the inquiry.
I like it.
All right. I'll do that.
I will take everybody else's silence as agreement.
All right. Any other concerns? I'm gonna put Lori on the spot, because Lori, you were asking about some of this stuff with regards to confidentiality last time, and just a really great perspective of kind of coming in and going like, I know about it, but I don't know about it, and I need some direction here. So what was your reaction to the additions? Is it enough? Is it too much? Or I don't know.
No, I do think it's enough. And actually, after I read it, I was just thinking, it caused me to think about how I might discuss this with my own clients and as well. I already talked to them about their information when the way that we convey it. And when we draft protective orders, we're talking about, making sure they're okay with share file. And I was actually, this actually caused me to think about whether I need to add something into my contract when they hire me about AI, and about our methods of storage and sending information back and forth. So yeah, but this opinion and your changes to it, that's what caused me to think about it in that way.
So along those lines, just yesterday I was talking with one of our new advisory members, Elizabeth Johnson, who's a partner over at Wyrick here in Raleigh, but she's a privacy and information security law specialist. And I told her about this one, it's just kind of giving her a flavor of what's pending before the ethics committee, and said, your expertise is going to be very valuable in this one and in other. We always get technology questions, right? But she had said something about, talking about whether or not you need to inform your client about AI. She was saying, well, yeah, I mean, put a clause in your fee agreement. That's going to be something that needs to be a bit more kind of thought through and considered, just to let folks know. But then she posed the question of, I don't know if it was either a hypothetical or something that she or someone at the firm had experienced, where a client said, I forbid you from using AI. I don't want you to use AI in any way on my case, because I just don't like AI. One of those things where you don't know what the reasoning is, but a client has said that. And I was wondering, just in that moment, do we need a different inquiry to add that component of, not just does a lawyer need to inform the client, as we addressed in inquiry number 5, but must a lawyer follow the client's direction when the client forbids the lawyer from using AI? I will tell you, my gut reaction to that question was, I think there's the goals of the representation clearly are dictated by the client, but when you get to kind of how you do your business, it's probably an it depends sort of situation, because how are you using AI? If you're using AI to search case law, and somebody's insisting that you go to the stacks in the Supreme Court and research everything hard copy, I don't think that's reasonable that a lawyer must acquiesce to that demand. Although it may also be a red flag. Maybe you don't want that client.
Right. Or it's time to renegotiate your rate.
Right. Right. So I guess I pose that to you all now to, I feel like we're in a really good spot, and maybe that's a part of the feedback we get from this opinion, that this might not be a one and done publish, but I also don't know if that's something that, like, that sounds like a kind of an extreme example of a client. I don't know how many clients are really going to just insist, do not use AI. So maybe it's not something that needs to be addressed by the opinion, but nevertheless, I think she's going to offer some good insight. And I know just on that point about the fee agreements, she was kind of right there saying, yeah, these clauses need to make our way into lawyer contracts to give folks a heads up. So anyway, I'll stop rambling.
Well, the term AI is so expansive that, if you're the client and you're hearing that, you may say, well, what exactly is AI? What does that mean for me and my information? And I think you do need to have some awareness if you're going to use it, what happens with their information, and that goes back to the opinion. So
right.
So I do think it's helpful. I think the opinion's great, and thank you for all the hard work you've put into it.
Oh, thank you. No, I think our conversation last time was just really helpful in trying to tease out what we need to emphasize here. And frankly, I think this is something that could be tinkered with forever. But the point is to get something out there that is helpful to the profession in their service of the public, and I think we might be at least on the right path here, if not have something that's worthy of publication. And again, we'll probably get some good feedback. I think we definitely need to point it out, as I typically will do. I'll reach out to some of the like bar association, maybe their privacy and data security sections, just to say, hey, we've got this out here, and we need everyone to kind of put on their let's participate in the self-regulation of our profession hat, and help us with this opinion. So we'll definitely get some feedback. Is there any other feedback that anybody wants to share? Changes, suggestions, concerns, or do you all feel like this might be appropriate for a publication?
Yeah, Brian, I have
I have-
question. I'm sorry, somebody else can go ahead. Okay. To address your issue you're just talking about, I feel like it's sort of implicit in the opinion where you do a good job of dealing with factors and situations in which you need to get informed consent to use it versus when you don't. If you need to get informed consent, then to me, that says that you got to listen to the client if they don't give that consent. But if you don't need to get informed consent, like you're using LexisNexis or Westlaw, and that's more internal practice management stuff than it is outsourcing things. I think you call it substantive outsourcing of legal work versus internal process management or something along those lines. I think that's the answer to your question, is that if you have a duty to get informed consent, then you have a duty to listen to the clients when they don't give that consent.
Yeah, I agree with that, Lamar.
Yeah. My question though was your change under inquiry 2, where you near the end where you add the stuff about the Florida opinion. Last paragraph there, right above inquiry 3. I'll give you a second to get to it. It's you say in their second sentence that just with any third-party service, a lawyer has a duty under Rule 5.3 to ensure blah blah blah.
Mm-hmm.
And so when I read that, I thought, well, hold on. I thought we said earlier in the opinion that we're not calling AI a non-lawyer assistant for which Rule 5.3 applies, but then I see otherwhere where we are citing to Rule 5.3. And even later in the opinion, we cite to 2007 FEO 12 that talks about non-lawyer assistants and Rule 5.3. So I'm a bit confused. And I guess my confusion stems from the fact that, and maybe it's a distinction that doesn't have a difference, right? Like whether we call AI a non-lawyer assistant or not, maybe it doesn't make any difference. But I guess my confusion stems from the fact that if you look on the third page of your opinion, under opinion number 1, it's near the bottom of the big paragraph in the middle, paragraph that begins Rule 1.1 prohibits. Yeah, but at the very end there, it says that we're not prepared to classify AI as a non-lawyer assistant under Rule 5.3. But then we go later in the opinion to sort of say, apply Rule 5.3. So help me understand.
Yeah, no, it's a great question. This is one of those things, I guess this is one of those issues where if I'm not articulating what's in my head well enough for how I'm making that connection, that's an improvement that needs to be made. I think the statement here in this inquiry, this one at the very bottom of this paragraph here, is really just kind of say that that AI itself may not be a non-lawyer assistant, but the principle of a lawyer being responsible for something that is doing work remains consistent. And then in that part of the opinion, number 2 that you're referencing, I guess I'm both applying the principle of 5.3, but also that this inquiry deals with a third-party company and their AI offering or their AI service that they offer. And so, kind of like when you outsource, I don't know, maybe it's IT services, you have managed services at your firm. if they are doing something that's not compatible with your responsibility, just being very flippant with safeguards and firewalls and all that stuff, then that could be attributed to the lawyer. But more importantly, just kind of 5.3a says that the lawyer has a responsibility to make sure that that basically the third party service or non-lawyer assistant, whatever you want to call it, or whatever it might be, it's the lawyer's responsibility to make sure that their practices are compatible with the lawyer's professional responsibility. So I guess that's where I'm making the connection. I intended this sentence to be kind of the connection upon which any reference to 5.3 is built, that we are applying the spirit of 5.3, the principle of 5.3 to AI, whether we're talking about the third party actual company that's offering the program, or if a lawyer ends up using or creating AI within its own universe, within its firm. So that was the thought process, and maybe it's not working, or maybe it's not clear enough. I see Ellen, you've raised your hand. I don't know if you have a thought there you want to share.
You're on mute.
You're on mute, Ellen.
Sorry, I'm having it calling through my phone. I had the same question as Lamar, and it seems to me that there's a question, I'm not sure if we've ever answered it, Brian, and that is a third-party service a non-lawyer assistant? So if Lamar employs a web designer, and that web designer puts the Lamar is a certified workers' comp up, right, and whatever, right? Lamar's clearly violated the advertising rules, but my understanding is Lamar has not violated 5.3, but I may misunderstand that.
I guess I have.
I think that's it.
Yeah.
I think that is the kind of the issue, right? Is that?
Yeah, I think
if we're looking at AI today as a third-party service, then it would be the same as another third-party service that we would use. Or are we looking at it as a paralegal who would work for Lamar, who built the website, and then Lamar is going to get into trouble both for the advertising violation and for 5.3 failure to supervise?
Right. So I think I guess I have interpreted 5.3, and I think our opinions, like the one on software as a service, has interpreted 5.3 to say that 5.3 covers both the people you employ or the outside services that you retain. Because the 5.3 starts off with respect to a non-lawyer employed or retained by or associated with a lawyer. And I think we have on staff, and I think in those opinions, they set the stage that 5.3 covers the folks that you utilize to facilitate your practice of law in a very broad and probably oversimplified statement. But the paralegal that you employ, clearly there's a direct connection right there. But then like the software as a service, if you go with your buddy's cloud service based on servers in his basement, then there's no firewalls or anything like that, and you're aware of it, then I think a lawyer could be held responsible under 5.3 for not securing the information, not complying with 1.6. Maybe that's not a reasonable effort, but if there's no attempt to even inquire with that third party, hey, what do you do? How do you safeguard this information? What sort of security measures do you have in place? Because I'm entrusting you with the confidential client information. I see what you're saying, that it's almost kind of like, do you get a double whammy? Do you violate both 1.6 right. and 5.3? My interpretation is yes.
And when the third party service is non-human, but generating things. And I think that is I think Lamar's pointed out something really important about this opinion that we should clarify. And I'm not saying we don't clarify it in the way you've explained it. I just think we need to explain it in the opinion, how we reconcile those two.
Yeah, so I think, yeah, if this program is generating something, I think, and this is, I mean, this is where I think we'd started our conversation, or I know I'd mentioned in I think the August meeting that we had, that we may need to look at 5.3 to clarify whether or not 5.3 explicitly addresses programs that generate, because it's like right now it's this weird thing, I guess, again, with my interpretation of 5.3 being expansive to not just, not just the people that you actually employ, but also the services that you employ. Whether you're talking about, I often think of IT services. That's the biggest one. If you outsource something to someone else, uh, then you would be not, I guess, again, the language of 5.3 talk about employed, retained by, or associated with. That it's basically someone outside of you that's a non-lawyer, that's helping with something, an investigator for that matter. You hire an investigator to go look stuff up. That sort of thing, it's if you're utilizing some other resource, company, person, that's not a lawyer, but you're utilizing their services in the facilitation or the provision of your legal services, then 5.3 would apply. And it may end up in kind of a double whammy sort of situation if something actually occurs. But there's still the prospect. I look at 5.3 as kind of like articulating a proactive responsibility to make sure that the person that you're relying upon is doing things in a way that's compatible with your services, whether it's a marketing firm, advertising firm, an investigator, IT firm, whatever it may be. And so I think but I think there's the language in there. It contemplates a person. It contemplates a human, I think, or a company. And I guess that's one of the things with this question about AI. AI is developed by someone, and it's owned and run by someone or some entity. And so when you're using ChatGPT to draft something, are you relying upon the program, or are you relying upon the folks that programmed and own it? Maybe that's one of those things that maybe it's a distinction without a difference. But I think we're getting closer and closer to the point where, when AI is generating things, it's not the programmer that's created it. It's not Westlaw that is searching for something, or whatever it is. I guess it is creating its own content based upon how it was drafted. It feels like it's inching closer to the independent, autonomous, creative mind that can exist within a human. And so I think that's maybe the question for 5.3's future. Does it need to be clarified that 5.3 applies to these types of independent programs, even though they're created by someone? But I guess for the purpose of this opinion, I made the connection by articulating the spirit of the rule being applicable, that we're not going to say it's a non-lawyer assistant per se, in the sense of, kind of equating it with a human, but that it's the idea that a lawyer is responsible for the product, I guess you would say, of or maybe the handling of legal services that have been provided to them, or they're giving services from this outside source in the course of their own representation. A lawyer needs to prospectively make sure that that service, that person, that company is doing something in kind of in a way that's compatible with the lawyer's professional responsibility. And perhaps we just need to say that much more explicitly. That's where,
What if you change? What if in that paragraph Lamar pointed out, the paragraph above inquiry number 3, where you say, just as with any third-party service, a lawyer has a duty under 5.3 to ensure the AI. What if you change that so it disassociates 5.3 from the AI, and it becomes about the entity that is offering the AI? Lamar, does that help, you think?
Yeah, I'm sitting here wondering why we need Rule 5.3 at all in this opinion. I mean, other than a footnote to say, AI is constantly evolving, whether it, to the extent to which 5.3 applies or could potentially apply, is not something decided by this opinion, or something that defers that issue to the future, where inevitably we're going to have to deal with it in Rule 5.3, because we're talking about the same sorts of things anyway. Under Rule 1.1, 1.6, you've got independent duties under these other rules that, Brian, you do a great job in this opinion of extrapolating. So I'll ask maybe a crazy question. Why do we need 5.3 at this point?
So I'm trying to sort that out in my head, because for one, I think you're right. We have independent duties: competence, confidentiality. Those are really the big ones. 5.3's reference, to me, the value is, and I guess I base this on prior opinions that also reference 5.3, particularly with regards to a lawyer utilizing a third-party service, like the software as a service, like online banking or whatever it might be. 5.3's reference, particularly 5.3a, saying that a lawyer has this prospective duty, that you need to look into this stuff before you actually, like, kind of look before you leap. There's a part of competency too. Competency, I guess it's a slight difference in the sense of, if you're going to represent somebody and maintain the appropriate competency, then of course you need to know all about the case. You need to, educate yourself on those different things. But then there's also that comment talking about, lawyers need to be aware of the changes with regards to technology and how they impact the practice of law. But 5.3, I think, offers maybe a basis in the rules that basically says, yeah, lawyer, you need to know what you're talking about under 1.1, but when you are looking to incorporate other services that are not fellow lawyers, you have a duty to make sure that what they're doing is compatible with your professional responsibility, that you can't just kind of say, well, this looks like a really good program, I'm just going to go ahead and go with it, and find out later that I didn't meet 1.6c or what have you. But it's really kind of at the outset, you need to do that research. And I understand that it almost feels kind of redundant, perhaps, to say, like, you have a duty. Of course you have a duty.
I tend to agree, Brian, that we should keep it in there, because I think makes it consistent with prior opinions that we have issued that reference 5.3, specifically the guidance that we rely upon here from 2011 FEO6 refers to Rule 5.3 along with the other ones. I don't think we're necessary, and I think by saying that we're not prepared to say that this is a non-lawyer assistant, although technically it is a non-lawyer assistant, right? I mean, AI you're using it as assistance, and it's not a lawyer. That I think we're referring to 5.3 as much as anything to alert the lawyer to the expansive responsibilities that they have, and not necessarily to say, we're going to come after you on a Rule 5.3 violation. I mean, is that, I don't know.
Yeah, I'll offer this kind of comparison too. It's similar to we've had disciplinary cases, lawyers and trust accounts, right? And let's say a paralegal has been kind of put in charge of doing reconciliations and ends up, essentially embezzling funds, and doctoring reconciliations and so forth. And usually in those cases, then the rules that are cited are not just the trust account rules, but 5.3. It's not that the lawyer engaged in dishonest conduct, but the lawyer had a duty when they were basically delegating a task to someone that's not him or herself, to make sure that the person receiving this task knows what the lawyer's professional responsibility standards are. And it's, I won't say it's always a 5.3 association, but when you dug into some of those cases and you see that there was no training, there was no training on, or maybe even just kind of requirement that the person read through the trust accounting rules. And that's why their records are a complete mess and aren't compatible with the rules at all. Because it's kind of two separate duties. You have the duty to handle the money correctly and in a way that safeguards the funds. But then you also have a duty when you're delegating it to proactively educate that person, make sure that they're going to be doing something that's compatible with your professional responsibility. And I guess I kind of look at it the same way here. We have a duty to safeguard the information in and of itself. But if we're going to delegate that duty, or maybe not delegate the duty, you can't delegate your professional responsibility, but if you're going to delegate a task to someone, then it's your responsibility to also make sure that that person knows what your professional responsibility standards are, what the parameters are on your conduct, and how they may need to perhaps heighten their own standards to receive this task from you. Otherwise, you might need to go elsewhere. So that's kind of I guess the perspective on 5.3.
So Brian, does that mean if Craig decides to use a Lexus product at Parker Poe, and he sits down with the salesperson, that he has a duty to educate that salesperson about his professional responsibilities as they relate to the product that Parker Poe wants to use. And then that salesperson who has no direct control over the product has a duty. I know we don't regulate that duty, but theoretically, then that salesperson has a responsibility to either tell Craig, we do or we don't comply. And if they say we don't, and Craig wants to use the product, then he's got to work with the larger Lexus people to make sure that that product does comply.
So I don't know if it's so much the education of the salesperson. Like 5.3 talks about a lawyer making reasonable efforts to ensure that this third party.
But it says it's responsible for the conduct of such a person.
That 5.3C makes the lawyer responsible for the conduct if they intentionally tell somebody to do something that they're not supposed to, or if they become aware of something that this third party is doing and they don't take corrective action. So 5.
Okay.
That's when it gets attributed. But the 5.3 just has the general requirement of making those reasonable efforts, and that's where 2011 FEO 6 comes in, that I try to articulate here, like the experience, reputation, and stability of the program. You're working with Lexus or Westlaw or what have you. You're working with Microsoft. I don't think any of us who use OneDrive need to you reach out to the designers over in Washington State and check with them and be like, hey, do you guys keep things safe? I think you can rely upon there's reputation, there's experience, there's stability. You look at the terms of service. I mean, I think that's something that, let's be honest, a lot of folks, probably somebody sitting in this room right now, doesn't always look at the terms of service for my own personal things. I should, though, because I think that's where I would be educated on how people are doing things. I don't know. I was about to make an example that's way too common that brings up all sorts of questions dealing with a very popular email provider. But still, it's I think the point being that yes, we are allowed to make these reasonable efforts in a way that I think, looking at these reputable companies that have a history and maybe in their terms of service that they have efforts to segregate and keep confidential information, particularly when you're dealing with this. I think with this new AI stuff and how it can use, whereas I don't think Lexus is taking our very generic searches for case law. And frankly, I don't know how that, you might be able to draw some sort of connection between the generic search for a case or some other resource on Lexus and a client that somebody might be representing. But to me, this is really getting into more of the draft a brief with these parties listed, a motion for summary judgment, articulating the standard for, I don't know, obtaining a preliminary injunction or whatever it might be. That's where I think you get more specific, and maybe that's where a lawyer needs to look into the terms of service or the agreement to see how information is handled But yeah, I think 5.3 still does, again, it's that very vague term, reasonable efforts. What are reasonable efforts? We try to articulate some, but it's really going to be dependent upon the circumstances, as stated in 2011 FEO6, and then try to kind of bring forward here into this opinion.
Brian, may I make a quick suggestion that may
Yes.
deal with this issue? So this, again, on the page 3, that line we were looking at.
Yeah. This last one?
Yeah. Maybe a footnote or maybe another sentence, but something that says references to Rule 5.3 in this opinion are not intended to create duties, obligations, whatever, above and beyond other rules, but rather are offered to provide further clarification of a lawyer's professional responsibilities under these other rules, or guidance, or I don't know. Because to me, I'm still struggling with, and I can't be the only one, where we say Rule 5.3 doesn't apply, we're just applying the principles of it, but then later on in the opinion, we're still citing to Rule 5.3. Like, I think that's going to create confusion. We're not applying it, but we are. We're not saying AI is a non-lawyer assistant, but we're referring to the rule talking about non-lawyer assistants.
Right, right.
So I think something just saying we're referring to 5.3 to provide guidance, because there are principles that emanate from the rule that provide further guidance for attorneys to comply with these other rules or these other obligations of competence and confidentiality and whatever you want to list.
Right.
But that by citing to Rule 5.3, we're not creating any additional obligations beyond just extrapolating from the principles. That's a very wordy way of what I have in mind, but maybe something like that can take away any confusion that might exist.
Okay. Well, do you think, I think this is to Ellen's point, if referencing, instead of talking about AI, the amorphous blob that is AI, if we focus this on basically this last sentence, what if we deleted that? Because really what we're talking about is not so much the program as much as the company that has created the program. That is the third party. That would be just like any other software as a service. That's the case manager, the cloud computing and all that. I know AI is generating stuff kind of, and I guess that's the question, is the generation born of the developer, the company that has the tool, or is the generation truly independent? Because all of this stuff is owned. It was created and it's owned by someone. And maybe that's the thing that this sentence offers confusion, because we're focusing on the program itself as opposed to the entity, the Westlaw or Lexis that created, developed, and is now offering the program, which in that situation, it's just like anything else that we've ever used for software as a service. Would that clarify it? Maybe just that sentence is just too confusing to have in there because it distracts. What do y'all think?
I think that would help. At the end of the day, this is a question you've posed before in other of these subcommittee meetings, Brian. It's, if I'm on the grievance committee or if I'm prosecuting at DHC, am I adding 5.3 as a basis for prosecution or not? Right.
And so, yeah, no, I think that would be the thing of, looking at, I draw to that, perhaps maybe it's an appropriate comparison, maybe not, but if you went with a cloud storage company that you didn't do any inquiry into, you didn't look into it, you didn't talk with the person, you didn't make reasonable efforts to ensure that the person is actually safeguarding. You just heard that they are offering a service and you went with it. Would that be not just a failure to preserve the confidentiality of the information, but also because you delegated it to something or someone, you didn't have your server on site, you weren't keeping it on your personal hard drive, your laptop, whatever it might be, but you're actually using a cloud service that now puts it in someone else's hands, which is permissible, but you didn't take those reasonable efforts to look into it, would it be both a 1.6 and a 5.3? I think the prior opinions would say yes.
Yes, that's right. I mean, if we want to be consistent with 2011 FEO6, that's exactly right.
Yeah, I think it'd be charged as such too, in a disciplinary case. Maybe that's not appropriate, but I guess that's the thing. When you bring in a third, I think that's the thing with 5.3. When you bring in something outside, you're sending your information somewhere else, whatever it is, you're incorporating a third party services. That's when 5.3 makes an appearance. And so I think that would be, of course, this is also one of those things that maybe I'm curious to see the full committee's reaction to. Yes, Lori.
So I think if you delete that sentence as a whole, it makes it seem more like this would be enforced through 5.3. So if you delete that sentence, it might be worth making a footnote at the end of where you've cited 5.3A and B, or at the beginning when you at the beginning of that sentence when you say, maybe it's two sentences up, when you start talking about Rule 5.3, it might be worth making a footnote that says, note at the time of the issuance of this opinion, the Ethics Committee has not defined AI as a non-lawyer assistant, or this rule does not determine whether AI as a whole is a non-lawyer assistant, because the term is so broad.
Right. Well, and I wonder if that's the part to clarify that the applicability to 5.3 or of 5.3 is based upon the use of a third party company or some third party service in creating and offering this AI program. Because that's what maybe, in that way, I was thinking about AI in too much of the ether of what it is and all that. But it's really ultimately, like I said, it's created by and owned by someone. And they're offering, just like Westlaw's offering an AI service to search through hundreds of thousands of resources to respond to your 5-word inquiry in a second. So maybe it's the company itself. And I think I still think it's questionable. We can have that. Maybe I don't know if maybe I don't want to say it's questionable. I do think 5.3 applies when you bring in someone else. You send the work. You rely on something else outside of your firm for that service, or even within your firm, because it's really outside of the lawyer. It's outside of your own capabilities and within your own control. That's when 5.3 is supposed to kick in. So really, it's just a focus on the company as opposed to this notion of AI. So maybe it's just strike it all together and clarify that the applicability is based upon the fact that AI is owned and used or developed by someone, some entity. Lamar, does that I get what you're saying.
Yeah. No, I think what you just said makes a lot of sense. I'm sorry. I know we all wanted to have this done, but I do think we need, if not another paragraph, at least another sentence or two that says exactly what you just said.
Okay. Well, I feel like there's something to be put here, and if I can, we don't want to rush something. We wanted to get it right as opposed to rush it. So my thought is, let me take a crack at a sentence or two to clarify, because I think that's all it's going to take. And I'll send it out to you all. We're publishing a supplemental agenda. It's probably going to be over the weekend at this point. There's one new inquiry, and then I was hoping to include this. And what I can do, if y'all can't get to it and take a look and say, like, yeah, that was good, or no, we still need to discuss, we can still include it because it'd probably be good to get some other eyes on it too. That we can have a discussion at the full committee meeting. And if we don't feel comfortable recommending publication next week, that's okay. It's okay. We want to get this right. We want to get it right as opposed to get it fast. So let's maybe we can just kind of go with that. But I'll go ahead and get this thing drafted up and send it out to you all. And if you have feedback, if I nailed it, then you all can kind of collectively determine whether or not you want to recommend publication.
Looks like Ellen has something she wants to say.
Yes.
Hey, I know y'all are ready to go. I just want to say, Lamar, please don't apologize, because I think this is hugely important too.
Yes.
The second thing, Brian, when you look at it as a person, as the person or the company and not as the program, I do think there's a sentence in the paragraph above inquiry number 3, your second new sentence, that you might change to clarify what you're talking about.
Yes.
So that it's not the AI, right? It's not the tool, which may or may not have human-like characteristics at some point, but it's the right.
Yeah.
And then I had one other tiny comment in the first new paragraph. It's the second paragraph of the opinion where you say, how people have been using AI, and you say AG online legal research through common subscription programs. I think there are different kinds of that now. Some are extractive, some are generative. And I think it might be worth saying widely used, or tools that we've been using for a while, to make sure that we're clear and that we recognize that there's different types of online legal research tools, some of which are extractive and some of which are generative.
Okay.
That's it.
I see what you're saying. Okay. Yeah, I'm gonna just highlight this for my own purpose. And all right, well, I will
Brian, can I just
yes.
say one quick thing?
Yes, please.
About your editor's note at the top.
Yes.
That you're planning to add. Will you say that you may update, not that you will update, as information becomes available?
Yeah, I was going to say may as opposed to will. Yeah, just to clarify.
Yes.
Thank you.
No, thank you. That would be, if I was
and make sure to clarify it as a not exhaustive and
right.
doesn't purport to be up to date or anything like that. All right. So looks to me like we're 10 minutes over time. Is there anything else? Do you feel like, Brian, you've got enough to get us to the meeting?
I do. Yeah.
And so the plan is at the meeting, you're going to add a sentence or two and then present it to us there, or are you going to send? Or are you going to send
it to you
that to
before
us?
then? I've got a 12:30 coming up. But I'll
Okay.
be back in my office, I would anticipate, by 2, at which point I'm going to try to incorporate these changes, because these aren't huge changes.
No.
I think I'd like to think that, and hopefully, I'll simmer on it for the next hour and a half or so, and then I'm going to send you all something by the end of the day, as soon as possible. But I'll send you something by the end of the day, and you can take a look at it. I'd already talked with our new ethics chair, Judge Dorothy Hairston Mitchell, about the supplemental agenda that we might need to publish it just over the weekend, based upon what happened with this one, because it feels like we're very close. And so if I can capture what we're talking about today, then hooray. But I think I'll still include the draft opinion in the supplemental agenda, even if I don't hear from everyone, just so we can, and I'll clearly it's a draft. But then everybody can see where we're at. And if it's in good enough shape and you all feel comfortable, then we can recommend publication. But I want to stress that this is one that we do not need to recommend publication if we're not ready. So and I totally echo Ellen's thoughts to you, Lamar. No, we can always make this better. By the time we get it out there to everybody, it's supposed to be a helpful tool for the benefit of the profession as well as the public. And so to the extent we can clarify things, let's do it now rather than later.
Thank you.
Yeah. Although depending on how people respond to your sentences, it may be a quick straw poll at the beginning of the subcommittee of the full committee meeting where I say something to the subcommittee. Let us know if we're recommending publication, because if we are, why not go ahead and get it done? I don't want to put it off another 4 months just because of the procedural issue of doing things or whatever.
Right. I'll say, if you want to, I'll put this in the email as well. You can email me directly, or maybe email me and Warren, whether or not you feel like it's ready for publication. I don't want to get into a habit of hitting reply all, because if we start all replying at the same time, we might be hitting into an open meetings act. But just email me and email Warren and say, I think this is good to go, or I do still have a little bit of changes that I'd like to see before I feel comfortable. And don't hesitate to say that if that's how you feel, truly.
Yeah, I'm not trying to push it, but if it literally is a tweak here and there, I hate not to have be able to present it to them as a subcommittee recommends this for publication if it's ready.
Right.
I guess that's my point.
Yeah. Well, you all will hear from me. I would expect about mid-afternoon. Like I said, I'm running off to a meeting right now, but I'll be back in the office around 2 o'clock.
Thank you.
Right. Thanks, everyone.